Hello, I'm Bill Peterson, Minnesota estate planning attorney. We're all acquainted with the situation when a minor child needs to have a guardian because his mother or father has passed away. But what about at the other end of the age spectrum when an older parent needs help on handling the day-to-day decisions and carrying them out for himself or herself? That's when we're talking about guardianship. The issue is whether a senior citizen or even a younger adult may need a guardian to handle his or her personal needs, or a conservator to manage that person's finances. At different times, our office has been retained to represent the children who want mom or dad to have a guardian or a conservator, and at other times we've been hired by a parent to assert his or her competency to handle their affairs. It is an obviously emotional situation because the parent usually does not want to give up his or her autonomy. Also, the Alzheimer's disease or dementia can leave a victim with a false sense of what he or she can manage. On the other hand, some children may want to rush to a guardianship when mom or dad slows down a bit or becomes somewhat forgetful. On the darker side, some children want to get and use mom or dad's money for themselves while the parent is still alive. This situation can become further complicated when there's a blended family of a second marriage, or when mom or dad becomes enamored with a new significant other whom the children do not approve. The children may become suspicious that mom is being financially exploited by a man they consider a gold digger. On the other hand, the children may refuse to accept the fact that dad has become emotionally or sexually attracted by someone other than deceased mom. There is no doubt that in such circumstances, legal battles can sometimes become very emotional as well as expensive. The reasonable alternative is that family members communicate with each other. Unfortunately, when it comes to parent-child or sibling communication, some families, unfortunately, are terminally dysfunctional. Sometimes communication can be opened up by a neutral clergyman or impartial family friend. Even that doesn't always work with the distrust that seems to be inherent in the so-called blended families. Under the Minnesota Probate Code, the courts give preference to alternatives that are less onerous than a guardianship or conservatorship. This can include powers of attorney or health care directives, which used to be known as living wills. In planning for disability and estate matters, it is always wise to confer with a qualified professional while the parents and children are competent and emotionally calm. I'm Bill Peterson, Minnesota estate planning attorney. I'd be happy to talk to you about your family's needs for conservatorship, guardianship, or healthcare directive, as well as a power of attorney. Give me a call at 952-921-5818.